Welcome to week 3 of contract management. As usual, I am your instructor, Emmanuel Ortiz. This week's lesson focuses on managing contracts within the Belize procurement system. Our objectives are contract administration within the Belize public procurement framework, how to draft valid, clear, enforceable contracts and identifying and avoiding common drafting pitfalls, translating legal and technical requirements into contract terms, and understanding the responsibilities of the contract manager and oversight bodies in ensuring compliance, managing relationships, tracking deliverables, mitigating risk, and upholding transparency, accountability, and value for money. We should recall that a valid contract is one that the law recognizes and enforces, giving rise to legal rights and obligations. Contract drafting is critical in contract management because it establishes the legal framework that governs the rights, duties, and obligations of parties, ensuring clarity, precision, and enforceability. It is important that we have well-drafted contracts. A well-drafted contract reduces ambiguity and clearly defines roles and responsibilities. It allocates risk and provides mechanisms for resolving disputes, making it easier to manage day-to-day administration such as monitoring deliverables, tracking payments, and handling changes. Now let's look at key contractual clauses. These are clauses which are essential provisions within a contract that define the rights, responsibilities, and expectations of the parties involved. They typically include clauses on the scope of work, payment terms, duration, confidentiality, warranties, indemnity, termination, and dispute resolution. These clauses ensure clarity, manage risk, and provide a legal framework for addressing potential issues during the contract's performance. The first such clause is definition and interpretation. The contract must clearly define terms which may be interpreted differently by others or may be seen ambiguous or unclear. Having a separate clause for definition and interpretation provides clarity by defining the terms used throughout the contract, reduces ambiguity, and ensures consistent understanding. These terms may be defined within an individual clause or under one clause which includes definition for terms, phrases, and acronyms used throughout the contract. Furthermore, we look at scope of work and services and terms and duration. Scope and work and services. This outlines the specific deliverables, tasks, or obligations of the parties. This prevents disputes over what is or isn't included. Terms and duration sets the effective date, duration, renewal terms, and termination provisions. It also includes clauses which sets out clear termination rights, example, termination for breach, non-performance, or at convenience. We now look at clauses such as price and payment, warranties and representations, and indemnity. Price and payment. This specifies the total contract price, payment, schedule, method, and conditions. Warranties and representations. Protects parties by ensuring products or services meet stated standard and comply with laws. Warranties create enforceable obligations for breach and warranty and allows claims for damages. Indemnity. This allocates risk by requiring one party to compensate the other for specific losses or damages. Indemnity should be clear, specific, and proportionate to the risk. Finally, we want to add in a dispute resolution clause. This sets out how disagreements and/or breaches will be resolved, whether by negotiation, mediation, arbitration, or litigation. An example of this is placing in the document, any dispute arising under a disagreement shall be first referred to mediation under the Belize Mediation Act before resorting to arbitration or court proceedings. Common contract drafting mistakes and their importance to contract management. In contract law and contract management, common drafting mistakes such as vague language or ambiguities, omissions, or overly complex legal terms can lead to misunderstandings, disputes, and financial loss. Clear and precise drafting ensures that all parties fully understand their rights and obligations in contract management. In contract management, avoiding these mistakes is crucial because a well-drafted contract promotes accountability, reduces risk, and promotes a solid foundation for effective performance and dispute resolution. Here are some common mistakes we want to avoid. Ambiguities. These occur when the wording of a contract can be interpreted in more than one way. This often happens when the terms are vague, undefined, or inconsistent. Omission. An omission happens when an essential term of the clause is left out, making the contract incomplete or unenforceable. Overly legalistic language. Using excessive legal jargons or outdated terms makes contracts difficult for non-lawyers to understand. You must ensure that all parties to the contract are able to clearly and easily understand its terms. We have examples of some common drafting mistakes that includes ambiguities, omissions, and over-legalistic language. It is important for us to read the examples so that we know and understand what to avoid. So now that we know how to properly identify different situations which may require different types of contracts and are able to draft a valid contract, let's explore further the role of the contract manager. The contract manager ensures that contracts are properly drafted, executed, and administered throughout the entire life cycle. That's from initiation to closeout. Their role bridges legal, operational, and administrative functions, ensuring that agreements are both compliant and effectively implemented. The contract manager ultimately maximizes value, minimizes risk, and ensures successful outcomes throughout the entire contract relationship. In the pre-contractual stage, the contract manager identifies procurement needs, conduct market research, prepare solicitation documents, evaluate bids, negotiate terms with suppliers, and finalize contract agreements. Once a contract is awarded, the contract manager monitors the contract performance against deliverables and KPIs, or key performance indicators, manage payments and invoicing, process contract changes and amendments, and maintain all contract documentation. At contract completion, the contract manager verifies that all deliverables have been received, conduct final performance evaluation, process final payment, archive documentation systematically, and captures lessons learned for future procurements. As with all other roles, skills and knowledge are required to be a successful contract manager. These skills include legal and regulatory awareness. This is knowledge of laws affecting contracts such as the Labor Act, Public Procurement Act, and contract law principles and beliefs. Negotiation and communication. The ability to manage discussions with contractors, consultants, and stakeholders, and to properly negotiate contracts so that value for money is received. Analytical and risk management skills. This identify potential breaches or financial exposures early. Documentation and reporting. This maintains detailed records of documents related to the contract from initiation to closeout, inclusive of all correspondence, changes, and approvals. Leadership and ethics ensures transparency, fairness, and accountability in contract performance. Financial literacy. You must understand budgets, pricing, and payment mechanisms. Further to skills and knowledge required to be a successful contract managers often use tools to assist them in managing. These may include contract database, meeting minutes, reports, and project management database. Aside from the skills and the knowledge required for effective contract management, there are some tools used by contract managers in order to track their contracts and make it easier. Those include Microsoft Excel or contract tracking software, public procurement portal used by the government of Belize, document management system, and performance dashboards. Now let's look at public procurement and Belize's legal and institutional framework. Public procurement refers to the process by which public authorities,